Hang out for 3 hours.
I am great. How are you? Happy Wednesday. Why you That's right. Oh, I'm sorry, Jake. Hey, Ryan. I'm good.
How are you?
So we'll, yeah, so on this one. No, not me.
I know I did. You did great. Yeah, Mark, I did. Good. Somebody broke it. Somebody broke it. Okay. Broke it. Yeah. Oh, okay. All right.
I am. After I hug you. Okay. I like that.
I'd like to call the General Laws Committee to order. Mr. Secretary, take the roll.
Senator Onder.
Here.
Senator Liblow.
Here.
Senator Brown.
Here.
Senator
Eichel.
Here.
Senator Hummel.
Here.
Senator Rizzo. Here. Senator Watson.
We have a quorum. At the request of a couple of committee members, we're going to go into executive session first and exec on a couple of bills. Do I have a motion to go into it? I move that we go into executive session. Do I have a second? Seconded by Senator Brown.
All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. So the first bill we will take up is Senate Bill 20. Do I have I move that we take up Senate Bill 20. Do I have a second?
Second.
Seconded by Senator Brown. All those in favor say aye.
Aye.
Those opposed say no. That's appear to have it. Do have it. So Senate Bill 20 is Senator Brown's prevailing wage bill. You remember we heard that one last week, and we taken it up. I move the committee do pass Senate Bill 20.
Second.
Second by Senator Libla. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. So any discussion on Senate Bill 20? Seeing none, Mr. Secretary, call the roll.
Hold it.
Senator
Hummel has.
I'm sorry, Senator Hummel. Senator Hummel.
Listen, Senator, the only thing I'll say is I can admit the fact that maybe there's some modifications that we can do that would make things more agreeable, but I don't think it's really going to be out with that.
Thank you. Thank you. Okay. I move that we do pass Senate Bill 20.
Second.
All those in favor, aye?
No.
I need a roll call.
Roll call.
Okay, roll call, I said. Mr. Secretary, call the roll.
Senator Onder.
Yes.
Senator Libla.
You get mine.
Aye. Senator Brown.
Aye.
Senator Eichel.
Aye.
Senator Hummel.
No.
Senator Rizzo.
No.
Senator Watson.
By a vote of 5-2, you have to pass on Senate Bill 19. Senate Bill 20. Senate Bill 20. And I make a motion that we take up Senate Bill 182. Do we have a second?
Second.
Seconded by Senator Libla. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it. As you remember, Senate Bill 182 is my bill to repeal project labor reviews. Any further discussion? I move that we do pass Senate Bill 182. Do I have a second?
Second.
Seconded by Senator Libla.
Senator Onder. Senator Libla.
Aye.
Senator Brown.
Aye.
Senator Eichel.
Aye.
Senator Hummel. Senator Rizzo. Senator Watson.
By a vote of 5-2, you have recommended Senate Bill 182 to pass. I would move that we go out of executive session. Do I have a second?
Second.
Those in favor say aye.
Aye.
Those opposed, no. The ayes appear to have it. The ayes do have it. So we will now be open the hearing on Senate Bill 210, my bill, and I will also present Senator Brown's Senate Bill 87, both collective bargaining in the public union context. And I will be turning the committee over to the able hands of Senator Libla, my vice chair.
Thank you, Senator, and good morning, everybody. Next up, we will go over Senate Bill 210 and Senate Bill 87. So you're going to take testimony on both bills.
We will. In 3 minutes.
Okay. Yeah, we're going to allow about 3 minutes on your testimony, and Senator, when you get down there, you go for Senate.
Oh,
Yeah, I was wondering about that.
Yeah, I wasn't sure mine was either. Is this not working at all? No.
I'm generally a loud person anyways.
Well, I don't mind doing that.
Well, I think we hear each other, but
I know,
the
I
audience.
know.
Yeah.
Stalling for time. Take minutes. Maybe we'll stand up here quick. Testing, 1, 2. Come on, Roman, work on it.
Okay, okay. Well, what do you think, Sen?
I think we need to hang on.
Yeah, why don't we?
We need to, have this, hard copy. I nominate James.
We're happy to put this off for a week.
Couple months. Couple months. Is Tim Green
I do have green light.
Green light?
Yeah.
Well, I do too.
But I had it. Test. There we go.
Okay.
Hey, we're back in the. All right, first up, Senate Bill 210 and Senate Bill 87, being presented by Senator Onder. May proceed at your discretion.
Thank you.
Yeah, we're good.
We're good. Thank you, Mr. Chairman, members of the committee. For the record, Bob Onder from the 2nd Senatorial District. Thank you for the opportunity to present Senate Bill 210, the Government Union Accountability Act. Much of the discussion this year about labor reform has been devoted to private sector union issues, predominantly right to work, PLAs, and prevailing wage. But just as important is labor reform in the public sector or in the government union sector. Compared to private selective sector collective bargaining, which received a big boost with the Wagner Act in 1935, government union collective bargaining is relatively new. In fact, FDR himself opposed government union collective bargaining, saying, all government employees should realize that the process of collective bargaining is usually understood, cannot be translated into the public service. But after John F. Kennedy's Executive Order 10988 in 1962, government unionization rapidly gained a foothold. Missouri passed its first law allowing public sector collective bargaining in 1965, and in 2007, the Missouri Supreme Court expanded government union collective bargaining essentially by judicial fiat. Government union members now exceed private sector union members in numbers. It's important to recognize that government unions are in many ways fundamentally different than private sector unions. In the private sector, employers are individuals or companies. Government, and by its extension, the people, are the employers in the case of government unions. In addition, government unions with their aggressive political activity often end up electing their own bosses. Finally, government unions are in many ways not held to the standards of transparency and accountability that their counterparts in the private sector are held to. The Commonwealth Foundation gives Missouri a D in government union labor laws for failing to either protect the taxpayer or the union members themselves. So my bill has several provisions. First, Senate Bill 210 gives Missouri government workers a voice in who represents them in their work. Fewer than 3% of government union workers have ever themselves voted for representation by their union. The present decertification process is inadequate. It places the burden on the worker, it's cumbersome, and it risks retaliation. Senate Bill 210 calls for recertification elections every 2 years conducted by the Board of Mediation. These would, of course, be secret ballots. And allow workers to renew their current representative, choose a new representative, or choose no representative. This can be done efficiently and cost effectively. For example, it is done every year in Wisconsin using a telephone voting system. Second, government unions in Missouri operate under a cloud of secrecy relative to their counterparts in private sector unions. In 1959, in response to several high-profile cases of labor union corruption and embezzlement, Congress enacted the Labor Management Reporting and Disclosure Acts to require yearly filing for private sector unions. The so-called LM filings allow workers to know where their union dues are going. In many cases, they have allowed interested parties, often the workers themselves or sometimes the press, to investigate and sometimes to uncover embezzlement and corruption. A recent example of this would be the KC Star investigation of the Boilermakers Union in 2011. SB 210 creates reporting transparency that mirrors the private sector LM filings. Likewise, while Missouri's Sunshine Law requires almost all government meetings to be open to the public, government bodies routinely close meetings for collective bargaining. In these meetings, officials set public policy, including work rules. They spend the taxpayers' money. SB 210 creates transparency by classifying these meetings as public meetings. And when these meetings are open, union members themselves often show up in large numbers, as well as the public. Finally, government union contracts often include provisions known as evergreen clauses, which can bind parties to an original contract for years beyond the expiration of the contract. This is a problem because taxpayers can be held to an agreement negotiated in good economic times years later in bad economic times, which is not good for the government entity, for services, or for the taxpayers. So SB 210 limits contracts to 2 years. The substitute differs from the as-filed bill in a few important respects. The main change is that every other year elections, as opposed to annual elections, are required by the sub. Now, Wisconsin does do recertifications annually and efficiently and at low cost, but to many, every other year was felt to be more workable. The sub also limits the term of collective bargaining agreements to 2 years, something I mentioned. And there is language about the timing of elections and clarification of other provisions of the language. Just to comment on the fiscal note, the note is based on the requirement of annual filings. And annual elections, and with annual elections held the first Tuesday in April. Of course, with so many elections being held at one time every year, that would require more personnel at the State Board of Mediation than if you stagger elections over 2 years. As this committee substitute basically does the elections on the anniversary of the certification date. And finally, the fiscal note also seems to assume that the State Board of Mediation is going to reinvent the wheel, including hiring a lot of additional personnel and getting new computer systems. I'd note that in Wisconsin, recertification elections are conducted by a phone-based system by the American Arbitration Association for about $1.50 per worker per election, and there are reputable contractors who will do this for as little as 8 cents per worker per election. And that should all be more than be covered by the sliding scale fee schedule in the bill. Well, in summary, SB 210 is a pro-worker, pro-transparency reform bill. I urge its adoption by this committee, and I'd be happy to take any questions.
Thank you, Senator. I apologize. We have effected a small coup. Vice Chairman, we will do our best to carry on. Are there any questions for the bill sponsor? With that, Senator, do you have a list of folks who would like to testify on behalf of Senate Bill 210?
Yes, I do, and I'm sure this committee is in capable hands. My first witness is Jim Foster.
It's a privilege and pleasure to be here today. Thank you very much. My name is James Foster. I'm an attorney in private practice with the firm McMahon Berger. We practice labor employment law on behalf of management across the United States. 210, as Senator Onder described, really does provide what is long overdue for the employees and the citizens of the state of Missouri. By providing that those labor organizations that have placed themselves into the workplace and into the state government are required, therefore, to provide a copy of or provide information regarding their actual finances so it's available to the public, to the press, to the members, to the cities, to the government agencies, to the school districts, etc. The idea is simple, that the more people are informed, the more they can make informed choices. Mike, is that dead? Hello? I'm dead? There you go. Thanks, sorry.
There we go.
Thank you. What 210 does for the public sector is no more than what's required, for example, to the IBW. The IBW annually files LM2s, 3s, 4s, all kinds of reports. And this only requires the portion of the one report being the financial report. It would disclose dues, it would disclose income, and where that income is spent. The IBW does that already. This is asking nothing more of the state unions in the state of Missouri for public employees than what's already being done in the private sector for private employees and private members of labor organizations. The idea of a 2-year, I'll move on quickly with my time. The idea of a collective bargaining agreement or memorandum of understanding having no more than a 2-year limit or expiration falls in line with the usual budget process of most governmental agencies and most governmental organizations. Usually there's a budget every year, and somebody has to work on a budget every year, pass a budget, agree to the budget, pardon me, and that budget comes up as a matter of discussion in advance of its usual enactment. To that extent, it would be difficult, if not impossible, for labor organizations to avoid having to want to be part of that discussion. And a 2-year framework falls within that much better than a 3-year, 5-year, 10-year, or ad infinitum agreement. Time up.
Very good.
Thank you.
Thank you for your testimony. Are there any questions for the witness? Thank you, Mr. Foster. I appreciate it. Don't forget to fill out a testimonial on the way out.
I did somewhere. I'll find it again.
All right. I think the idea is we're going to move back and forth between those that are for Senate Bill 210 and those that are opposed to Senate Bill 210. Is there anyone here in opposition to Senate Bill 210 that would like to testify?
Thank you, Senator. AFL-CIO President Mike Lewis gave up his seat, so I'm going to assume it's okay for me to go first. My name is Bradley Harmon. I am president of Local 6355 of the Communications Workers of America. It's good to see Senator Wasson again from my home county, Christian County, and I appreciate the chance to be here today. I joined the State Workers Union in 2003 when I got hired as a children's service worker straight out of Mizzou. I was transferred to the city of St. Louis, which, as you know, is a place that has real problems with crime, poverty, and not surprisingly, child abuse and neglect. I was really surprised. I started off in the Wainwright building, and they moved us to a location on South Broadway. And there was a Quick Trip really close to our location. And it got robbed a lot because it was in a bad neighborhood, and they had trouble keeping staff. Interestingly, we were working in the same bad neighborhoods, and our members also face threats to their safety and well-being all the time when they go out and do their work. We have a turnover rate in the children's division. I think if you look on the OA website, In Department of Social Services, which is I think the closest number you get, I think the turnover rate is about 25% per year. If you drill down into children's service workers, the turnover rate approaches 50% per year. And if you look in some of our more difficult to work in areas like St. Louis City and Jackson County, the turnover rate is higher than 50% per year. There was a study, the Kansas City started the story a few years ago, I believe, and found that 75% of the children's service workers in Jackson County had less than 2 years of experience. Our job is extremely difficult and it's extremely time consuming. I got put onto the bargaining committee first time in 2005, I'm sorry, 2007, when Governor Blunt was in office. I've been on the bargaining committee in 2007, 2010, and then in our last round of negotiations, which started in 2014, concluded in 2015. All of the agreements that CWA has reached during the time that I've been on bargaining committees are available online. They're available on our website and on the Office of Administration website. It's public record, and you could certainly look, and you will find no money in any of our agreements. So the state has consistently refused to ever negotiate with us over salaries, staffing levels, healthcare benefits. The state's consistent position under Democrat and Republican governors has been that those are matters for you in the legislature. Part of what is wrong with this bill is that it solves a lot of problems that honestly do not exist. The collective bargaining model that is referenced in Wisconsin has never been adequately or adequately, in my opinion, because Wisconsin state employees make substantially more than Missouri state employees do, has never been applied to state government in Missouri. So it solves a lot of problems that don't exist. And to pretend that this bill is not an attempt to completely crush the ability of public employees to engage in any kind of collective bargaining is difficult for me to fathom. The level of work and paperwork and the demands on our time at Department of Social Services are truly intense. It is incredibly difficult for our members to do the things that are absolutely essentially required to make sure the kids are safe. We routinely put in 50, 60 hour weeks, and to add substantial burdens to our ability to maintain an organization is clearly an attempt to make it harder for us to organize. I have to ask, I believe that the majority in the legislature wants government to be small and to do as little as it is necessary. I'm sorry.
We're beyond time.
I appreciate it. I would just, if you really want to help public employees in this state, figure out a way to pay us fairly. And then if you want to look at reforming other things, okay, but it seems like your basic obligation is to pay public employees fairly. This is a distraction from that.
Thank you. Are there questions for this witness? All right, without further questions, thank you for your testimony. Please fill out a witness form before you leave. With that, is there an individual that would like to testify in favor of Senate Bill 210?
Next will be Brian Hay. Yeah.
Good afternoon and thank you. My name is Brian Hay. I'm a labor and employment attorney with McMahon Berger. Our firm has represented management for over 60 years. I'll be brief. I do a lot of municipal bargaining. One of the main complaints I hear from employees is they don't know where their dues go. And I hear that a lot, and I think this bill solves that problem. And I think it's a pro-employee bill, and I think the members in most bargaining units would be for this bill.
Thank you. Are there questions for this witness? Senator Hummel.
Don't they have a right? Yes. Yes.
So how does this solve that?
They know where their dues go.
Okay. And that's going to solve that? All right. Well, I see where he's going with it now, but it took me a while to get to that point.
Yeah, if I could.
One other question real quick. I just curious. So if there's these recertification elections every 2 years and all this, I assume that you'll get a lot more work out of this in your law firm. Probably gonna be a lot more incidents. We have a new election every 2 years, right? Is that correct?
Paula Conde will test, I'm sorry, are you finished?
I wasn't, but go ahead.
No, say we have a client here who will testify. McMahon-Berger's position in bargaining has always been, we want the city to bargain with the union without attorneys involved to save the citizens money. That's always been our position.
What you get paid for?
No, we don't. They call us, we give them advice, but we're not present during bargaining sessions.
When you give them
We
advice,
try to save,
when you give
we
them
try to save
advice-
our clients
When you
money.
give them advice, or you get paid for that?
Yes, we do get paid for giving advice.
Senator, I have a quick question.
Sure.
Very briefly. I apologize.
No problem.
Just on page 21, section 6, every labor agreement shall include a provision stating that in the event of a budget shortfall, the public body shall have the right to require modification in economic terms of any labor agreements. Are you basically saying that in any budget shortfall, the bargaining unit doesn't have the right to renegotiate with you? So like, in other words, the state would then not be obligated to go back to the union and say, listen, we have a budget shortfall, we need to renegotiate this. They just have to take it one way or another.
Well, as I read that, they go back and bargain again.
Where do you read that part?
We're page 21, and
They shall
And
have the
so-
right to require the modification, so that, is that not just telling them they're going to have to accept it? And again, I'm not an attorney, so.
okay. So, yeah, in the very last couple of lines on that page, they will have a period of 30 days with which the public body and the labor organization shall bargain over any necessary adjustments to the economic items of the agreement. So,
Every labor agreement shall also state that the public body deems it necessary to modify the economic terms of any labor agreement. The public body shall so notify the relevant labor organization and shall provide a period of 30 days which the public body and the labor organization shall bargain over. Okay, I did that. Thank you.
okay, thank you. And just, I wanted to just.
But at the end of the day, they're going to have to accept it.
If modification is necessary to overcome the budget shortfall. I just wanted to just mention something in response to your question of the witness. You sometimes hear the statement that in the public employee context in Missouri, public employees, quote, have right to work. And that's not really true. There's nothing in Missouri law right now that there may soon be, but that bans agency fee clauses, union security clauses in contracts. It is the case, though, and this is where people get that impression, that it's pretty rare. Agency fee clauses in public employee contracts are pretty rare.
I'm not aware of it, and I
Yeah.
assume maybe there are. I just don't
There
know.
are a couple out there, yeah, but we can talk about that later. But the other part of your question was oh yeah, so you said the reporting requirements.
Right.
Again, right now, the IBEW Local 1 files LM2.
Going back to this organization.
Yeah, right now, we're private sector unions under federal law have a reporting requirement that we mirrored in this bill. So all this does is extends that same requirement and really the safeguard for the union members' money to state law, because as you know, state law is governs public employee unions. Thank you.
Further questions for the witness? Thank you. Please fill out a witness form before you leave. Now we'll switch back to opposition. Is there anyone in the audience that would like to testify against Senate Bill 210?
Afternoon. My name is Jean Duker, and I am an attorney in Clayton, and I represent the Missouri Fraternal Order of Police and the Missouri State Council of Firefighters in opposition to this bill. The main thrust is that it is our belief that the bill actually interferes with the collective bargaining rights provided public employees under Missouri's Constitution, that there are certain provisions and collectively essentially eradicate the rights that are guaranteed union members and bargaining units under the Missouri Constitution. I know there's a substitute bill, which hopefully I will see at some point, and I can talk to any one of you offline about specific provisions that I have trouble with, and I'd be happy to talk with you, but we at least wanted to make sure that the committee and the senators are aware that there are legal problems with the bill. And also, again, to reiterate that we also believe that this is a solution without a problem. I don't think anybody's against fair transparency, but when transparency turns into punishment and turns into burdens in order to affect the constitutional rights, that's where we believe this bill goes too far. So we are against it.
Now, if I've understood previous testimony, this would actually bring the reporting requirements in line with private sector unions, is that correct?
I believe that this goes a little further than the LN2, and I'd be happy to show you where I think it does go beyond that. And so, I mean, again, transparency is one issue, but the other issues of the recertification, how that's done, you're actually taking all bargaining power out of all local governmental bodies. Local governmental bodies contract for property, they contract for services, they contract all the time. And these kind of burdens are not put on public governmental bodies and being told how to bargain. And we believe that that fully interferes with the good faith requirement that's mandated by the Missouri Constitution.
But when you say that it's eliminating collective bargaining rights, I don't see an elimination of collective bargaining rights anywhere in the wording. Can you point that out?
No, it doesn't specifically say that. I believe the provisions and the burdens that are placed on the process cumulatively and separately interfere impermissibly on collective bargaining rights.
And which of the burdens would be greater than what we've seen in the private sector?
That whole process. I believe the disclosures are further with the officers and getting down into individuals. It's a little bit further than federal law goes. And so I think that some of those and not, again, being forced to, I think there's a huge legal problem with being forced to accept a contract. Once you've entered into a contract, the government, you have to be very careful how you impair existing contracts. In no other area of local governmental law or public governmental law does, are there provisions that say we're just unilaterally going to, bail out of this contract in any way you want. And so I think that this puts burdens and takes away the ability of public governmental bodies, and there's a lot of different kinds of those. It's not just the state, there's local governmental bodies, and they are now, if something like this passes, they are not permitted to bargain in good faith because there are certain provisions they have to abide by under state law, and I think that has not only legal problems, but also interferes with the good faith requirement.
Further questions for the witness? Thank you, and please fill out a witness form before you leave today. Senator Onder, do you have another witness?
Yes. Next witness is Bola Camby. Excuse me if I mispronounce it. People get under all the wrong all the time too.
My parents fight me. Good afternoon, honorable members of the General Laws Committee. My name is Bola Conde. I am the city administrator for the city of Brentwood. The city of Brentwood is a mid-county suburb that is in St. Louis County. As a city administrator, I am responsible for the day-to-day operations of the city government. Chief Administrative Officer, if you please. I am one of two that of the city council have designated to bargain on behalf of the city. I'm here in support of Senate Bill 210. In the public sector, we have an open and transparent process whereby meetings are conducted in public. Our budget process is open to the public. We have sunshine requests, which we are required by state statute to respond in 72 hours. This bill is a pro-employee, pro-worker bill. It allows for the same transparency, the same financial disclosure requirements that are required in the public sector, which is why I'm here in support of this bill today.
Thank you. Are there questions for this witness? Senator Hummel.
Very briefly, are your emails subject to sunshine law?
They can be, yes.
Okay. Different than this body, that's why I was asking. Thank you. In the interest of transparency.
If there are no further questions, thank you for coming today. Thank you for your testimony. Please fill out a witness form before you leave. Is there a member of the audience that wishes to testify against Senate Bill 210?
Thank you, Mr. Chairman, members of the committee. My name is Mike Lewis. I'm president of the Missouri AFL-CIO. And just briefly, there is no explanation in this bill in the local that I come from originally. We represent private sector employees in trucking and automobile dealerships. We have a very small amount of public sector employees that we represent in the city of St. Louis who are mechanics as well, but they work in the city garages. I don't understand, or I can't find in the bill where this bill would break down for us, how much of this report, who has to do this reporting, or do we have to report on everybody in the private sector as well as the public sector as well? And I think that needs to be addressed in this bill and dealt with before we can agree to disagree, which is what's going to happen, but still. And I'd be happy to answer any questions.
Are there questions for this witness? Thank you, Mr. Lewis. Please fill out a witness form, and we appreciate your testimony. So, Your Honor, do you have another witness?
Yes. Next witness is Patrick Ishmael.
Good afternoon. My name is Patrick Ishmael. I'm the Director of Government Accountability at the Show Me Institute. We support this bill for a couple reasons. The first is how the bill starts, talks about transparency. Private unions, by and large, already do this, so we don't think it's an undue burden for public unions to do the same. And then at the end, you start talking about workers' rights, decertification, recertification system we think is appropriate in this context. I would also say that as far as the fiscal note is concerned, I think that the biannual change is an important thing to keep in mind. I'm sure that those numbers will be rerun, but I think that will reduce the cost of the overall bill because it is going to be spread out over 2 years rather than one. And I would also note that in the first year, there are, I think, one-time expenditures which affect that figure as well. So, I'm happy to take questions.
Witness. Please fill out a witness form before you leave today. Is there anyone in the audience that would like to testify against Senate Bill 210?
Mr. Chairman, members of the committee, Otto Fajan on behalf of Missouri NEA. Could I inquire, you said 210, are we hearing 210 separately? Or should I leave a form for 87 as well? Separately, thank you, sir. Okay. We will just concur, I think, with the opposition testimony already about a number of concerns. I did want to bring to the committee's attention a couple of things. The first one was the comment somehow that the public employee bargaining rights established by the Supreme Court in 2007 by the Independence NEA case was somehow kind of an arbitrary act or a judicial act. They took great pains to try to not do that, but said when we look at Article 1, Section 29 of the Missouri Constitution, and it says all employees collectively, they simply couldn't come up to any other conclusion than substantially the Constitution and the people of Missouri have granted substantially the same bargaining rights to public employee and private employees without prejudice. And so I think there's perhaps a need to understand where that came from. We also would point out that the Association of Missouri NEA already provides most substantially the structure of the financial reporting information to our own members, to our members only website. And so that's available to our members. So for the most part, they know where their dues are going. And unfortunately, under this act, where they're going to be going in the future, is going to be paying the tax hike where when our people have taken the initiative, the default is that you don't have a union. The default is that you don't have representation. It takes the work, the will of the folks in a unit to seek that and to seek that election. It will now be imposed on them whether they wish to have a recertification election or not. We're going to be paying for that. So this
is essentially a tax hike, and we will then be reporting to our members on our members-only website that we will be paying this additional tax, and so a portion of our budget will presumably be going to pay for that. We have some concerns about the overall restriction of the process. We think that's going to impinge on both the employers and the employee representatives, and really feel like it's a significant constriction of the local control that we currently have now. So we have those all those concerns, the concerns that have already been expressed by the other opponents. We cite those reasons and happy to answer any questions.
Senator Rizzo.
Thank you. Again, this issue, as Bradley said earlier from the CWA, of this new reporting and new requirements and so on and so forth. Do you have any idea, maybe down the road or whatnot? This is more to the senator, because you brought up the pay issue again, and I was thinking about it earlier. To how we're going to pay for new reporting. If we're going to pay for it, are we going to ask the state workers who are pretty well at the bottom of the rung across the country to do more with the budget that they have, or we going to create an office?
So when you look at unions, and again, the reporting is at the level of the union. So it would be, in the case of the state, it would be the state CWA. In the case of, say, firefighters in eastern Missouri, it'd be IAF local, 2665. So, it's not a bargaining unit by bargaining unit reporting. These are big entities that are being asked to report. And I would sure hope that they're already employing accountants and people to do their tax returns to keep track of all of this data. The only question is whether it's going to then be also put onto essentially what in the private sector would be called an LM2 form and made public to the members. So I've never been on the NEA members only website to know what an NEA.
You're welcome to join, Senator.
Oh, okay, all right.
You have to work in public school.
Actually, I'm a teacher in a sense at the med school. But anyway, but no, to make it to require it is require private sector unions to do this kind of full open transparency that Congress decided was important in 1959 in the private sector. And that I'm not aware of any move by anyone, including the national labor organizations, to repeal the LM Act of 1959. We just think it's appropriate that public sector union employees should have the same protections.
Sure, I'll tell you, I've talked with the senator from the home area about how much more pay. Actually,
I wanted to follow up in response to
Sure.
that same question whenever it's time.
Go ahead.
So I wanted to make sure that the committee looked at the drafting of this to make sure that the intent is adhered to. If the intent is primarily to focus on, like for instance, for Missouri NEA, that Missouri NEA provides this reporting, versus also having that duty fall on each of our locals, even if it is a local that has 7 teachers. Are they going to be required to take on a substantial financial reporting, which can actually put in jeopardy little things that they often do, which are charitable scholarships for students, where we don't want the identity of the student to be revealed. There are issues there at the local
I'll tell you,
level.
just in general, for a group that really hates regulations and has a guy who froze a bunch of them the other day, that a lot of the stuff we're doing here is a lot more regulation. And
we're feeling that, Senator.
And I don't know, get used to the alternative fact world or one way or the other. And it's not personal to you, Senator. It's just I have seen over and over, we're stopping regulations and we're going to cut the red tape, and we're going to grow business, and we're going to this and that, and then we have a 20-page substitute that's basically full of regulation.
Well, again, regarding the reporting, when the regulation is something that requires openness, transparency, that can prevent members' dues from being embezzled, I am for that kind of
Well,
regulation.
and I will tell you, in all honesty, Senator, I will talk with Sarah, I will talk with the Senate about how IBW does it. And put himself out there.
He's not going to talk to you, sir.
And to Otto's credit, if it is a matter of whether it can be done in one group or you're gonna go local by local, so on and so forth, and all that. But it's just something that, my new time here, it seems like we're doing a lot of research, but I
Thank you.
I think that we all agree that we don't want to have burdensome regulations that stifle business, but I think it's also important to say, and I have a couple questions myself, that many of us see the role of government is to protect the rights of the citizen. And in many cases, particularly in the labor world, I think there's a belief in this body that the rights of the citizens are not being protected. And to illustrate that, you mentioned that the default state is to have no union.
correct.
And what percentage of employees must vote or sign to form a union in order to change that default state?
In our case, in the public education, there's no specific answer.
Okay.
Because there is no law. A school district could choose to abide by standards that would be applicable to a particular deviation, but there is no statute.
Is it typically something less than 100%?
Yes.
So
You call for the election.
in those cases, isn't that precisely an example of one group imposing its will on another group as a result of majority?
I'm not sure I follow the question.
Well, there's a difference between public sector unions, and this actually came up on the floor of the Senate last night. There's a difference between public sector unions and private sector unions, and that private sector unions are able to collectively bargain for what's known as members-only agreements. And that doesn't exist in the public sector. You're aware of this.
I think in general, like in education, it couldn't, because we have a salary law that says a teacher, say for instance, teacher pay needs to be pursuant to a salary applicable to all teachers. And our association wouldn't want to ask the school district to be in a position where they couldn't get the job done and negotiate for the whole salary schedule.
So if you're worried about one group imposing its will on another, and there are certain items in here that talk about decertification procedures, would you then be supportive of the possibility of members-only agreements in the public sector?
I think that the overwhelming need for the public sector to operate, there are needs on both sides of this equation. And there's a need for the public employer to operate in a way that deals with all of their bargaining unit. I don't think that there is a perception that those kind of member-only approaches would work well in the public sector.
Interesting.
And in fact, it would be illegal in Missouri.
Question,
it would be illegal in Missouri because they would. Yeah, with regard to salary schedule, the legislature has already enacted a law saying you can't do that, that you have to have a salary schedule applicable to all teachers.
Yes, Senator, just to get to you asked a good question about majority rule. Is the minority imposing their will on the majority? And I think that's not even really what's going on. What's happening is people who organized the union sometimes 40 years ago are imposing their will on members today. And except for the very cumbersome, very difficult decertification process, there is no democracy regarding public sector unions in the workplace today in Missouri or anywhere else. It roughly, perhaps 2 to 5% of government union workers in the state of Missouri have ever voted for their own union. So they may have voted to ratify contracts, but that question of whether or not to be represented by a union, that was decided in many cases decades ago. There's an excellent article, I'll try to get it for the committee, entitled "A Union Card Shouldn't Be an Heirloom." And again, especially in the public sector where we're dealing with government entities, government employees, and the taxpayers' money, I think that's inappropriate.
So, and then you would agree with me that this is not about just creating regulations, as the Senator mentioned. This is more about protecting the rights of those minority members so that they can, without undue process, decertify or take action that they feel is in their best interest.
This is a pro-worker bill. Senator, if I could just, Mr. Chairman, that process is symmetrical. In other words, the process to create and the process to decertify are symmetrical.
Understood. Are there any further questions? Thank you, and please fill out a witness form.
Thank you, Mr. Chairman.
Okay. Senator, do you have another witness?
Yeah, is Bill Brandis in the audience? Oh, you can't make it, okay. Is Brad Golden? Okay. Fire Chief, Herbertson?
Mr. Chairman and Senators, my name is Kevin Hervey. I'm the Fire Chief with the Rocky Mountain Fire Protection District. I'm a retired firefighter for the Osage Beach Fire Protection District, where I was a member of Local 3987. Several of us chiefs have gotten together, and we are in agreements with Senate Bill 210 with the provision of the economic provision in the bill, as far as that it has to be, the economics have to be taken care of on an annual basis. We would think that if both sides could be in agreements to an extended period of time on that it would behoove not only the public body, but the labor union to be able to negotiate a 2-year contract or a contract that doesn't bind beyond the terms of the governing body. Other than that, I don't want to bore you with everything that everybody else has already said.
Any questions for this witness? If I just have one question, which local did you say you were with?
3987.
And you don't believe that this bill would create burdensome regulation that would harm your members?
I am no longer a member with that union, but from being a member of that union, I think that this bill would only help the membership.
Thank you. Please fill out a witness form on your way out. Is there anyone in the room that would like to testify in opposition to Senate Bill 210?
Afternoon, Chairman, members of the committee, records, Clark Brown from the Missouri State Council of SEIU Service Employees International Union. Our relationship here, public employee representation, not the total balance of our members, but a substantial number of them, and well over a dozen public employee contracts that would be impacted by this, along with 3 state division agencies. I can't not move through some comment about this without saying we're here again. This legislation is somewhat familiar with like paycheck legislation, when we're required to do something on a repetitive basis here, whether this would be having these elections or signing union members up. But I can't not, excuse me, I cannot move through this without making the point. We've returned to these again and again, and I can't in my mind, because they do employee representation, see this visualization that we have workers asking for this. And while I can't agree with the fundamentals about employees need to have this choice all the time, and this election reoccur and be put in front of them every time, I can't get past the thoughts, if they're not here asking for this, why are we providing this fundamental idea of your choice? It brings a huge cost for them, because frankly, the 13 plus contracts we have, or what I inquired from the state board last year, the 611 public agencies that are certified at the board have to have these elections every year. And now we're proposing, because when we looked at this legislation last year, that it had a huge fiscal impact cost. Now we're setting this upon the workers' own union to pay for it. I simply can't get past that. And I know this fiscal note's got to get prepared. I saw somewhere and I assume it was for the annual, was 400,000 in just staffing costs. But I think there's a lot of costs that come out of the member's pocket if you think about what we have to do on this reporting requirements about how do we carry those fees for those elections every year without that impacting their union dues being spent for that. So that's a fundamental point I wanted to make. I think that for a picture or an idea that we think a problem doesn't exist, I've been involved in decertification elections. They're certainly come just as easy, and as Agent testified from the NEA, it's a symmetrical process. It takes the same thing to start a union, or the workers need to petition. They have this opportunity through the regular contract terms that come around every time. So I think we're forcing recertification elections when they have this window that reoccurs every time in accordance to their union contract. So I hope that's helpful to make that point about that. I hate to get into some details. I do think that, because I haven't seen the substitute, but I do think that this legislation is going a little deep about outlining the collective bargaining terms here and about the items that can be bargained. I think those are typically agreed upon between the employer and the union. So I certainly am not a professional on the reporting requirements. I know that some of that does look similar to DOL-M2 reporting, but I do think there's some substantial other stuff about financial disclosures and all that. I have no problem with that. I take an ethics test every year that talks about all these, you can't have investments and so forth. But overall, I think we're proposing a very cumbersome process for the state board to have to manage with, I understand 611 when I called, and that's not counting police and fire because they're not registered all those. So what do we got, 700 plus elections all happening in July of every year that both the state board has to manage and all the public employee unions have to manage. That certainly will suffer a cost to the workers.
Thank you. Are there questions for the witness? Thank you. Please fill out the witness forms before you leave today.
The next witness is Jim Glenn.
Thank you, Mr. Chairman. My name is Jim Gwinner. For the record, I am a registered lobbyist, but I'm appearing here today not in that professional capacity. I serve on the board and one of the founders with the Missouri Century Foundation. Missouri Century Foundation, for those of you that may or may not know, is an organization created to promote free market principles and forward-thinking policies that work to ensure the health and stability of our state for generations to come. When looking at this legislation, it seems very easy to get behind and support this legislation, as government unions are in a unique position of not only being able to negotiate with public bodies, but also have the power through their political activity to influence who is elected and ultimately who they bargain with. Very briefly, and I know that's words that the Senate likes to hear, the rate of growth, the rate of public sector membership is 5 times that of the private sector. And look at the 4 provisions. It seems very, very obvious to get behind these. They don't represent, in our opinion, an onerous burden on the public body that is negotiating with the public union, and in addition to the taxpayer as well. Whether that be the biannual recertification, requiring the same financial disclosure reporting that the private sector unions have under the federal law, the increased transparency for meetings and documents, as well as clarifying some ambiguity. Thank you for your time and happy to answer any questions.
Are there questions for this witness? Thank you very much. And please fill out a witness form before you leave today. Is there anyone in the room that would like to testify against Senate Bill 210?
Good afternoon. My name is Mark Dalton. I'm with the St. Louis, Kansas City Carpenters Regional Council. Sad to see Hummel is not here. I was really wanting to talk about IVW. But no, we're like to go on record in opposing this legislation. I just want to point out the recertification section. We're the Carpenters Union, but we do represent a lot of St. Louis City employees. We represent about 1,500 city workers. 400 of those actually pay dues. So But there are about 43 different job classifications that we represent, be it animal control officers, city marshals, correctional officers. So when you talk about a biannual, and I believe it is between the last Tuesday in March to the first Tuesday in April. So in a 1 week period, we would have to have a lot of elections with each group that we collectively bargain for. So that is, to run that many elections is a big deal in a week. So just that along with some other things, but that's what I wanted to point out.
Yeah, Mr. Chairman, and Mr. Dalton wouldn't have, anyway, knowing it because we don't have a lot of copies of the sub here, but that's something that changed in the sub. So the recertification elections would be every 2 years on the anniversary of initial certification. So they would be staggered throughout the year over 2 years.
Okay. But yeah, I guess in the same sense, that's still every 2 years. That's a lot of elections. Unless we can maybe get 42 months in a year, that'd be great. We can do one of them.
Thank you. Are there questions for the witness? Thank you very much for your
Thank you very
testimony. Please fill out a witness form before you leave. So do you have another witness?
Yeah, next letter will be Vincent Bernuccio.
Thank you, Senator. Members of the committee, my name is Vincent Bernuccio, and I'm Director of Labor Policy at the Mackinac Center for Public Policy. I'm here in support of SB 210, and let's just talk a little bit about what the bill would do. This bill does basically two things: promotes transparency and promotes democracy. And it does so in a way where there has been really no legislative dicta one way or the other. Essentially, we're talking about a provision of the Supreme Court, a provision of the Missouri Constitution that the Supreme Court said now government unions can collectively bargain. This bill is simply codifying what is in the Constitution and bringing order to government collective bargaining. Let's talk about the democracy. First, it codifies how unions, government unions, are going to be organized. Second, it protects the secret ballot. So public employees can feel confident that they can vote for or against a union without intimidation or coercion. And second, just like we vote for state legislator, just like we vote for governor, just like we vote for president or Congress, it allows government employees, public employees, to vote for which union represents them at the workplace. And it does so if the model is as currently written for about $1.50 per vote. Folks, that's democracy for less than the price of a cup of coffee. And that cost is borne by the unions that are going to be able to collect dues from their future members from the recertification elections. And frankly, it's also on a sliding scale where wealthier unions will be paying more, and unions that don't have a lot of money will be paying less. So you could say it's quite a progressive scheme. Transparency, as you've heard, it simply mirrors what private sector unions across the country already do, what private sector unions here in Missouri already do. It makes the expenditures and receipts simple bookkeeping for government unions, just like the private sector brethren, makes those transparent and open to their members and open to the public for clarity, and also because sunshine is the best antiseptic. And it will keep them honest, and also it can also attract new members because now they can see, wow, these unions are spending money effectively, they're getting good contracts, which also will be made public, and I want that union to come represent me. And finally, one note about the decertification campaigns. There was a lot of talk about it being symmetrical. A decertification election in a union is not symmetrical. When a union comes in to certify, they have the union, they have union organizers, they have a lot of money behind them, they have a lot of assistance for those public employees that want to unionize. For public employees, or any employee that wants to decertify a union, they have no help. They're up against the union, usually a very well-funded union, that is trying to stop the decertification. And they can't have help. In fact, they can't even use the company or the government copier, because that would be illegal.
You got about another 30 seconds.
With that, I would like to take questions. Thank you.
Not in your presentation. All right, any questions of this witness? Seeing none, thank you very much.
Okay, thank you.
Thank you for coming. Next up in opposition. Is there anyone next room, Senator, or you know?
I do not know.
Okay. I've seen a lot of people over there a minute ago when I passed by the door. I don't know. If there's anyone in the next room and you want to testify in opposition, please come to the next room over. Anyone else in support?
Gary Cunningham.
Okay. We'll see if someone shows up, Senator.
Thank you.
Mr. Chairman and Senators, I'm Gary Cunningham. I'm the husband of former Senator Jane Cunningham. Jane is ill, and I'm here to share her words in support of SB 210. This is Jane. When I left the Senate, I was elected to the board of directors of a local fire protection district that is unionized. We are a taxing political subdivision that provides fire and emergency medical services. The reporting itemization provisions of the bill are helpful, not only to the taxpayers, but especially to the union members. I once asked one of our union firefighters what their union dues were spent on. He replied, probably bar bills. They never tell us. In our district, those dues are $2,200 per firefighter per year, totaling nearly $500,000 every 2-year election cycle. And that's only from one fire district. There are over 20 districts like ours in St. Louis County alone. Union members are given no accounting for all that money they pay. They deserve a report. Remember, we are dealing with a taxpayer-supported government entity. Just like we as candidates for a government office are required to report our financial and campaign funding and expenses, this would do likewise. Secondly, the bill provides that collective bargaining be done in public. Our fire district started that reform a couple of years ago and was featured in an article by the Show Me Institute as an example of transparency and good government. Yes, taxpayers came, the press came, but what opened my eyes is the firefighters came to watch. Taxpayers and union members both have a stake in the bargaining process and want to see their representatives vigorously defending their interests. As this bill moves through the process, there is a priority item I would suggest being added. I would also alter it in Senator Brown's Paycheck Protection Bill, SB 21. As I said, I'm on an elected government board. We have absolutely no business collecting dues from our employees on behalf of an independent outside organization, especially one that spends the taxpayers' funds on political campaigns, generally in opposition to taxpayer interests. Permission is irrelevant. Payroll deduction for private purposes is unethical and not a legitimate function of government. Private banks provide the same service for their customers, and any union member can direct regular deductions. Government should not be administering this union program, period. This approach would also give the union members control of their payments when they feel they are not getting deserved services. I have witnessed those situations in our shop, and employees are helpless to stop payments. Senator Onder refers to the right to work legislation as worker freedom. This is worker protection. Thank you for your attention.
Thank you very much. Any questions? Go ahead, wait a second.
No, if there are any questions, I'd be happy to try it.
Okay.
I wish Jane were here to speak for herself.
Well, thank you very much for coming today. Any questions of this witness? Seeing none, thank you very much for coming today. Anyone else in support or opposition? Anyone else in support, Senator, you know of?
None.
Okay. One more call. Anyone else in opposition? What's our numbers here? Senate Bill 210 or Senate Bill 87. How about informational purposes only? Oh, I see. I thought we were presenting at the same time. We just took testimony.
He did not.
I see.
Yeah, we haven't done 87 yet.
I see. I looked at the wrong page here. Right. So next up, is that correct?
Yes. No, thank you. Just to say a word in conclusion, 210. One of the witnesses referred to this in some way interfering with the collective bargaining process. I would say this codifies and protects the collective bargaining process. So thank you for the hearing, Mr. Chairman.
You're welcome. So we're going to go
to SB 210. I'm sorry, SB 87 by Senator Brown. Okay, this will be my presentation will be very brief. I just summarized by saying Senator Brown's SB 87 really requires the every 2-year recertification elections, but doesn't do any of the other things.
Okay, just for the record, we concluded hearing on Senate Bill 210.
Right. So
now we're going to hear Senate Bill 87.
Yes.
And you're going to be presenting for
Senator Brown, yes.
Okay.
So Senator Brown's SB 87 requires recertifications of public employee unions every 2 years, but recertification elections conducted by the State Board of Mediation. And it does not have the other provisions of my bill that I discussed, but otherwise I think a lot of things I said apply to both bills, so I won't be repetitive. I would note that this bill has a fiscal note of about a third of what the SB 210 fiscal note was, and I think that is because it's every 2 years, and my sub is changed to every 2 years. So with that, I'd be happy to take any questions.
Okay, thank you very much. Any questions of the bill sponsors?
Just briefly on this one and kind of the other one too. I was over opposite in the House for 6 years, and I'm
Sure.
just curious if I don't remember if any of these ever did make it to former Governor Nixon's desk, or
No.
have they been even introduced before?
So no, they've been introduced, yes. So Representative John Weedman, who's actually here in the room, introduced this bill the last couple of years, not the House counterpart to this bill. And actually, on last year's Paycheck Protection Bill, there was a relatively modest reporting requirement that was, I will say, inspired by the reporting requirements of this bill. It didn't elaborate the specific reporting requirements. It just reported to the federal statute, basically BLM reporting statute. So, and of course, that not only did that make it to the governor's desk, it was vetoed, and it became within one Senate vote of an override.
Yes, for paycheck, pretty much. But yeah, okay,
Thank you.
Any further questions of the bill sponsor? We have any witnesses in support?
Yeah, I think some of my witnesses are still around. If they want to come up in their own order.
Anyone like to testify in support of Senate Bill 87, please come forward. Seeing none, Senator. Anyone in opposition to Senate Bill 87? Anyone for informational purposes?
Just turn in the form.
Okay. So, what's your form for?
87.
87. You're in opposition? Correct. Okay. All right. Otto's in opposition. Okay. Anyone else in opposition? You're in opposition.
Police and the firefighters, it's on the form that we are opposing.
Right. Okay.
Don't need to repeat.
Okay. Anyone else in opposition? Anyone for informational purposes only? Senator, you got anything else you'd like to close remarks?
I do not. Thank you for this hearing, Mr. Chairman.
You're welcome. Thank you for allowing me to be up here.
And the junior senator from the St. Charles did an excellent job filling in your stead.
If it's okay with you, then I'm gonna make a motion to adjourn.
That's okay with me.
Okay. Do I have a second?
Second.
All right. This committee has now been adjourned for Senate Bill 210. Thank you, everybody, for showing up.